This panel is about the recent European Court of Justice decision in the case of Google versus Spain. I think I have named it correctly this time?
It's the Google Spain decision. Just
Google
leave it
Spain.
with that.
And the reaction I've seen from a lot of Americans has been, this sort of panic that free expression is going to disappear from the internet. So the panel is really to discuss that and more broadly the right to be forgotten. I want to throw in at the beginning a quote from Simon Davies in 1997 when the data protection legislation passed in Europe, and I was writing a piece about it for Scientific American, and he said he was trying to convey the depth of this decision to adopt the data protection directive, and he said, you can no more cut a deal with European data protection than we can cut a deal with your First Amendment. And that this is now a fundamental law and a fundamental right. So I am going to, my three panelists are Judith Rauhofer, who is a lecturer at Edinburgh University. Emma, I don't know how to say your last name. Lanzo. Who's the Director of Free Expression at the Center for Democracy and Technology. And Mike Godwin, who is the Godwin in Godwin's Law.
That's all you have to say.
Yeah,
Well,
that's right.
This is actually relevant to a right to be forgotten
Don't
panel.
turn his microphone on.
It's because, the advantage of not being forgotten is that my reputation precedes me.
Yes. I've had two people ask me who you were today. So I'm going to start with Judith, who is going to try to explain the ins and outs of this really complex and messy decision, because I know she will have the facts.
Okay. Right. Okay. Hello, my name is Judith Rauhofer. I'm a lecturer in IT law at the University of Edinburgh, and I'm also a solicitor, and I have acted in data protection cases as such. I'm here as the token European, which makes it all the more different, or all the more interesting, because I'm originally from Germany, despite the fact that I've lived in the UK. And the reason why I'm raising this is that because even though I spent my professional life in the UK, my cultural imprint when it comes to privacy is very much German. And those of you who have followed history of the last 100 years may remember that the Germans have had one or two different issues with regard to the abuse of information. So that explains a lot with regard to that quote that Wendy just said about, and that explains a lot with regard to the importance that privacy has on much of the European continent in particular, where basically the right to privacy is seen as something that is very essential to the relationship between individuals and the state and the individuals and business. I have the very unenviable position to try to explain what Wendy rightly termed to be a very complex judgment. And I've made some notes, and I will probably bore you rigid at some stage. So when people start to actually yawn, I'll try and stop. But it is really very difficult to explain why this decision isn't as bad as people make it out to be without trying to put it into context of European data protection law. The most important thing that I think people need to understand as regards the difference between a US approach to data protection or to privacy generally and an EU approach is that in the US you are basically permitted to process, as we say, personal data unless there is a law that tells you not to. So whenever there is a kind of data processing activity that the law decides isn't necessarily societally desirable, there is going to be a sectoral type of regulation that regulates that. In the EU, it is completely the other way around. We are employing something that the Germans have beautifully termed the Verbotsprinzip, so the prohibition principle, which basically means that you are not allowed to process anybody else's personal information unless you have a legal reason for doing so. And that is, in a way, what the Data Protection Directive is all about. It basically includes 6 legal grounds based on which data controllers can process personal data. Those grounds are enumerative. It's a final list. Member states are neither allowed to add to that list nor to take away. The same 6 grounds apply all over the EU. And the ground that, there are various different grounds. Consent is one of them. Fulfillment of a legal obligation is another. There are certain public policy grounds. The one that is going to be interesting in this context is the widest of the lot, which is the ground, which is called the data controller's legitimate interest. And that basically means that commercial organizations have a right to process personal data if they have a legitimate, i.e. normally a commercial interest in doing so. That is, however, subject to a counter right of the data subject to say that you cannot use this ground if my interest in you not processing my data is overriding. And this is where we oftentimes have to do these balancing exercises, and that is a lot what the Google Spain decision is all about. Now, as a lawyer, I read the judgment, and I was actually really, pleased with the judgment, because what it effectively is, if you leave all the hype away, it is an interpretation of existing law, and we need that. I mean, the directive is quite old, but it has still not been fully interpreted, and particularly its application to the technology area is often very difficult. And the reason why the ECJ did this, or the CFEU as it's now called, is of course that when decisions are taken at national level by individual regulators, data protection authorities, they can go into different directions. So we have 28 member states, 28 national regulators. They could all interpret the directive in a different way. And this means that when one of the regulators or a national court realizes that an issue of interpretation is so important that really we need the highest EU court to pronounce on this, so that the definition is the same, the interpretation is the same in all 28 member states, that is when something is referred to the ECJ for preliminary decision. And that is exactly what's happened here. So basically, the court was asked 3 questions. And they were all relating to this idea of what rights does the data subject have. The data subject under the directive has 2 specific rights. One of them is the right to request that a data controller rectify, erase, or block personal data if the processing of that data does not comply with the provisions of the directive. So if you process my data unlawfully, I have a right to ask you to stop doing that. And I have a right to ask you to erase the data that you've done. The other right that the data subject has is to prevent you from processing in the first place if I have compelling legitimate grounds to ask you that, okay? So there are a number of issues that the court had to decide, and the first of those is, of course, well, this is Google. Google argued, well, we're an American company, why should we comply with EU law? So the first question the court had to answer is, does the Data Protection Directive even apply to Google in this context? And that's the easiest one in a way that they did. They basically just said yes. There is a definition in the directive which basically says that if you have an establishment in the EU and you process data in the context of that establishment, then EU law applies to you. And Google had this wonderful, very complicated argument that really the data processing was done by the search engine, and the court basically told Google back, yeah, but the search engine only works because you get the money through the Spanish company that sells the advertising. And they basically put the 2 together and they said, you're EU enough and you're targeting our customers and our people, our consumers, and basically get over it. You know, you're playing in our country, you're playing by our rules. So that is the first thing that is actually a really big deal, and that is quite that was quite encouraging for us EU privacy advocates, because of course we're having this discussion at the moment in the context of the EU data protection reform, where we are trying to put this territorial scope, this expanding territorial scope that takes account of the internet on a much more secure footing. And that has been very much lobbied against, particularly by US internet companies. And the court now has basically said, no, this is how it should be. And the funny follow-on from that is that very recently the European Council has basically decided that it actually agrees with that approach. So I'm afraid that one's here to stay. It looks like it at the moment. We thought there might be more of a fight between the Council and the Parliament, but it doesn't look like it at the moment. The next question, and this is again a very boring legal question, but it's very important for us, is Google actually processing personal data? And here is where people said, well, they're not doing anything extra with the data. You know, the data has been published by somebody else. This was an article about somebody who was owing Social Security monies, who lost a house and his house in the process. there was an announcement of an auction for the house, and it basically told people all about this, you know, that this guy had gone bankrupt and couldn't pay his bills and had lost a house over it, and here's you can buy the house. And that's the information that he wanted to have suppressed, shall we say. Not deleted, but suppressed in that he didn't want Google to link to it. So the question here the court had to answer is, does Google actually process personal data? Because Google argued, well, the really processor, or the person who processed it, was the original newspaper that published this information. And the court said no, because basically it went for a very pure legalistic interpretation. It looked at the definition in the directive, and it said processing is defined as A, B, C, D. So it's like collection, storage, use, and so on and so on. And he says, you are sending your spiders out over the internet. You are collecting data. It's very clear. It's processing. So then the next question was, is Google a data controller in respect of this processing? And this is, again, a legal question that is very, very important, because this is what triggers the application of the majority of the obligations under the Data Protection Directive. The majority of the obligations fall on a data controller. And this is a binary concept that Europe employs. Okay, so if you process personal data, you are one of two things. You are either a data controller or you are a data processor. If you are a data processor, you are processing it on behalf of somebody else. If you are a data controller, you are the one who determines the purpose for which you are processing. So the court said, this thing that Google does, this collection, this storing, indexing, displaying, disseminating, does it do that on behalf of somebody else, or does it do that for its own commercial purposes? And as soon as you ask the question that way, I think it's quite clear that there was only one answer. It was definitely doing this kind of activity for its own commercial purposes. In the same way as the original newspaper, of course, processed the data for its purposes when it published it. But that was a different type of processing and a different purpose. So the original data controller, the newspaper, is subject to the directive or the national law because of its type of processing for its purposes, but Google is subject to the same laws for its type of processing and its purposes. And that was basically the decisions, that was the three questions that the court had to answer to get Google into the court, so to speak, to get it into the arena. And at that point, they then had to say, okay, so now we say, we know that the law applies to Google and it applies to this type of processing. So now has Google actually complied with the law? Because remember, if it hasn't complied with the law, then the processing would have been unlawful and the data subject could potentially ask for erasure. If it has complied with the law, then the data subject would potentially have no such right. And this is where, in a way, it got interesting, because there are many, many different obligations that a data controller has to comply with. And one of those is, of course, this legal ground. It has to have a legal ground for processing. And the court has made it very clear that what Google has done is very much in its legitimate business interest. Okay? So it ticked that box. You have a legal ground. But then it said, okay, so now let's see if there is an overriding interest by the data subject. And this brings us straight into this balancing of interests between Google and the data subject. The important thing to notice here is that this is a different balance of interest than the one the court would have had to make if we had looked at the individual and the original newspaper publisher. Okay? And that other balance of interest was, in fact, already done by the Spanish regulator. Okay, the Spanish regulator had originally also been asked to order the newspaper to delete the online article from its archives, and the Spanish regulator had said no, because it had looked at this balance of interest and it had basically decided that in that relationship, individual newspaper, the newspaper won. But it didn't think that the same balance of interest considerations applied in the relationship between the individual and Google. So that was the question it sent upstairs to the ECJ. So the ECJ looked at the situation of the two things, and it made two very, very important pronouncements. The first of them is that the overriding interest of the individual flows from the fundamental right to privacy that the European Union protects as part of its Charter of Fundamental Rights, and that every European member state, every EU member state protects under the European Convention on Human Rights. okay? So this is a very strong right, and this is where Europeans feel as strong about that right as Americans feel about freedom of speech, okay? It's a very, very deep culturally seated idea. So basically, the court decided that prima facie, that right overrides Google's economic interest in doing this kind of processing. But, the court said, the right of the data subject to privacy is itself not unlimited. It is not absolute. And this is what the fundamental rights instruments say, both the Charter and the Convention. That right to privacy can be overridden by a conflicting right. And that conflicting right, for instance, is the right to free speech, the right to access to information, and all sorts of other rights. So what we're looking here, actually, is a very zigzaggy general rule and exception from the exception kind of system. So basically, the court said, Google has a legitimate interest in processing. The data subject has a legitimate interest in his privacy. That right to privacy normally overrides Google's economic interest in processing, unless there is something on top of that economic interest that makes the publication of that information important. And the example that the court has given us in this context is, for instance, if a person that is in the public eye, like a politician or somebody who is really, is important in something, if they are trying to suppress information that is actually relevant and that is actually in the public interest to know about them. So some of the some of the calls for, the world is coming to an end kind of things aren't actually applying really, or would not be enforceable under this judgment. A very good example that I think for a situation where the right to be forgotten, as they now call it, would not apply is, for instance, we in the UK has an expenses scandal a few years ago. I'm not sure how many of you have realized that. Quite a lot of our MPs were caught with their hands in the till. Quite a lot of them went to prison for it. Okay, and quite a lot of them came back afterwards, and they are now MPs again. Now, you can think about this as you want, but if any of those MPs were to go to Google and say, I want you to delete the links to all reports about me being found with a hand in the till, Google would be, under this decision, perfectly within its right to say, go away. Okay, because there is a public interest in that information being available, accessible, and so on and so on. On the other hand, and this is, I suppose, where the cultural feelings of different countries come in. We discussed this over dinner last night already. A situation where we would probably feel that the person could make such a request is, for instance, somebody who's committed a crime but who served his sentence, who would now no longer be required to actually even disclose that information about having been sentenced, if he applied for jobs or anything like that, because we have used this kind of context to allow people to rehabilitate. And if that person who has committed a crime, who has served his sentence, went to Google and said, can you please delete the links to all the reports about me being found guilty and stuff like that, there might be an argument in some countries, in some European countries at least, that they would say, no, that is okay. These links should be deleted because you should be given a second chance. You should be given a chance to actually participate in society without everybody who meets you and Googles you immediately finding out that once you, were caught for fraud or something like that. So if you are just a normal Joe Bloggs and you've made a mistake, you've paid for it, and you're trying to reintegrate into society and you want that information to go away, in the analog world, many European countries would have made the decision to allow you to do that by not requiring you to disclose this kind of information. And what the court has done, in a way, is to try to apply that societal consensus that we have in many European countries to an online scenario where that just no longer applies, okay? Just because something never fades out of the public memory, I suppose, and that is the bit that the court tried to replicate. So I'm stopping here. This is basically, hopefully, the summary, the quick summary of what the decision was all about, and I'll pass it on.
It's actually really interesting because there is this American tradition also of self-reinvention. And so I was kind of surprised that the Americans I kept running into were so unsympathetic to the decision. Mike, would you care to be Exhibit A?
Would I care to be unsympathetic?
You were talking about Zealand.
I'm happy to be unsympathetic. You know, I think we started out with, you know, certainly have been a couple of times in the last 100 years where the Germans have abused information. Not that they're interested in rewriting history at all, but there certainly have been abuses of private information in the European tradition. But also, the notion of, it's less a notion of reinventing oneself than maybe reinventing the past. Let me just actually, I'll tell you the story, you know, what largely does a lot to inform my thinking about this, and that's that when I was the general counsel for Wikipedia, we were sued in Germany by two convicted murderers. They had served their sentences, they were paroled properly, and Germany, in a way that I think is quite humane, says that when you have served your time, you are restored all the full rights of citizenship. I think that's actually good. But having done that, you know, they were convicted and sent to prison in '93, and then they were released in 2008, and the world had fundamentally changed between 1993 and 2008, so that search engines were routinely used by really everyone, so that when people do job research, you know, in the employment context, you know, they look up the fact that they look up your name and they discover that you were a convicted murderer at one time. That turns out not to be optimum for your job prospects. No, really, you know, not for any job, as it turns out. So they sued to have their names removed from the German language Wikipedia article about the murder. They had both killed. They had conspired to kill a German television actor. Or at least that was what they were convicted of doing. And the German Wikipedians, because it's you know, because it's the community of editors is a volunteer community, they said, well, we may not technically be under the jurisdiction of German law, but we'll go ahead and remove the names of the murderers from the article about the murder. And they did that, but then some dissident Germans went to the English language Wikipedia and put it in. And they basically wrote the English language version of the German. In fact, it's the only reason I know who Walter Sedlmayr was, the television actor, because it's an English language article. And put their names of the convicted murderers in. And at that point, the lawyers in Germany sued Wikipedia. And I was, at that time, the general counsel of Wikipedia, and Wikipedia had precisely one lawyer, which was me. So this is not a case where Google, which presumably has unlimited resources and unlimited money and unlimited legal talent, can be tasked to do really anything that a European regulator asks them. This is a case where a nonprofit whose purpose is to provide information to the world is being tasked to maybe honor a right to be forgotten, even though the servers and the information is hosted in the United States. So one of the questions that came to my mind when I read the ECJ, when I read the European Court of Justice opinion, is who's a controller and who's a processor? These are the questions that Judith raised. And it seems clear from the very language of the opinion that it's not limited to search engines. It's not limited to indexers. There are some efforts to at least indicate that there's some kind of exclusion for journalism and some kinds of exclusion for what legitimate purposes are. If you are in the position of thinking, do you want government to have blanket judgments about what legitimate data gathering is, that's an interesting set of decisions to make in an open society. And I don't think necessarily other countries would strike the same balances that Germany has tried to strike, or that Spain has. But what we did, of course, what I did was I had to do a sleight of hand to solve the problem. And so, because I didn't want to defend the case and then have to face another case next year or another 10 cases. So what I did is I gave all the requests and information to a reporter at the New York Times, who then published an article about the demand to Wikipedia to take down the information about the murderers. And of course, he published their names. So the purpose here was partly, of course, to at least have a really powerful co-defendant if I were sued in the New York Times. But secondly, to, in effect, send a message to anyone who ever sued Wikipedia that this is what happens when you sue Wikipedia. I get it in the New York Times, and the very thing that you want to have eliminated is going to be on the front page. Maybe inside, maybe it'll be in the front of the section, you know. You know, in the United States, there's a notion that Americans don't care about privacy or that we privilege the First Amendment over privacy rights. But as privacy rights have evolved in the United States, and I don't mean to suggest that it's a perfect privacy regime in the United States, I think I actually side with many of my colleagues in the European privacy community who think it's not. But what we do know is that we've defined privacy torts, privacy wrongs, in very specific ways that strike appropriate balances between the right guaranteed by not only the U.S. Constitution but the international human rights instruments to seek and to impart information, as well as to speak freely and publish freely. And the privacy wrongs are basically four, as they've been defined in the United States, which are false light misrepresentation. If you say something about somebody that's true, but it misrepresents them anyway, you can sue to have that, to get a remedy. You can actually prevent that from happening, or you can have it mostly undone. Misappropriation of your likeness for commercial purposes, and likeness can be defined somewhat broadly. That's clearly a wrong in the American common law system. Publication of embarrassing private facts. You know, if you had a hemorrhoid operation, or there's some other thing that was embarrassing in your life, or that you just don't particularly want people talking about on the front page of a newspaper, that can be a wrong. And intrusion upon seclusion. You have the right to prevent reporters and photographers from sort of creeping into your backyard and taking pictures of you, while you're sunbathing by your pool, if you're lucky enough to have a pool. So those are actually been fairly, and those are things that the consensus is that this covers a lot of ground in terms of preventing certain kinds of privacy invasions. But the important thing, I think, to remember is that the case in the ECJ opinion did not involve private facts. It did not involve private information. So to the extent that this is understood as an invocation of a privacy right, it is plainly wrong, because the information is non-private. It's not private. It's the information that was published was a government proceeding to auction a house for someone in bankruptcy. And you may think bankruptcy is embarrassing. I think it probably is for a lot of people. But the thing is, government actions to auction private property for repayment of debts ought to be understood as squarely within the public interest. We like to monitor what governments do. We're upset when we can't monitor what governments do. And if you don't believe me, talk to the people who are critics of the National Security Agency.
Yeah, but this wasn't the government.
I think it's my turn now.
No, but it wasn't government.
You're
misrepresenting
it's representing that a newspaper published facts about a government proceeding.
Actually, it was a statutory notice.
It was a statutory notice published in a newspaper. That's correct. The statute, it's not the case that it was published in a statute book. It was published in a newspaper. It was called La Vanguardia, in case you want to look it up. The issue here is not about privacy, but about taking public information and making it less accessible. And you have to figure out why you would want to do that. Well, I think there are some good arguments for people who believe that my dispute over the boundary lines of my property are is not interesting enough to be subject to publication 15 years after the case was resolved. That seems like a reasonable thing to say. But if you're talking about governments having a very vaguely defined right to decide what is in the public interest to publish, what is relevant, what is good public policy to publish, you end up having either giving the authority to decide what is published in search engines to Google, or you end up giving it to courts or other government bodies or regulators. And that, I think, is quite troubling to countries that have a strong free speech tradition. I'll just close. I mean, I could say a lot about this, obviously, but I'll close to make sure that everybody gets a chance to speak by saying, what if you're the next Google? What if what if you are not, hugely profitable company in Mountain View, but instead you're starting your own new search engine based on publicly available information today, and you do not have the legal resources or the money or the revenue, or your backers don't, to defend you if you are faced, if you're subject to EU jurisdiction, and I'll just assume that's a given. How do you defend yourself? Maybe you just don't get into the business. Maybe it suppresses what you do. Wikipedia, I think, clearly falls under the definitions in the EU directive, and I think it's worth pointing out that if we believe that the purposes of these digital technologies and the internet are to empower us to know more stuff, I agree that privacy rights need to be affirmatively protected in that kind of regime, but public information ought to remain public and not be, the idea that it's really still public if we store it only on paper and put it at the top floor of a 10-story building without an elevator, is ridiculous. I mean, it's an artificial constraint on our right to know public facts. And the important thing, and I'll just keep saying this one more time, this was a set of public facts about the litigant in the Google case in Spain, not private facts. It's not about privacy.
I think you mean the filing cabinet at the bottom of the stairs that are out with a sign on the locked, disused laboratory that says "Beware of the leopard." I want to throw a couple of things into the mix before Emma sort of tackles things. One is that Google removes results for lots of reasons. In DMCA notices, copyright. There's an outfit in Germany called Jugendschutz, I believe, that recommends the removal from search results of things like pro-anorexia and pro-suicide sites because they're harmful to children. There is apparently, I had not heard of this, but it was mentioned on the EDRI list, an outfit called Legit Script, which seeks to make sure that the only ads you see on Google are from legitimate pharmacies in the US, I believe that's right. And in the UK, there's the Internet Watch Foundation, which recommends the removal of links to child porn. And there's lots of reasons why things are removed from Google search results. And the other thing I wanted to throw in was a comment made by Reagan, who is on a different panel right now from Access Now, that one of the legacies of this decision so far has been to set privacy activists and freedom of speech activists against each other in a way that's actually quite damaging to both sets in terms of achieving the goals that we actually do want to. Could have turned that on. In terms of achieving the goal, I always assume everybody can hear me anyway. In terms of achieving the goals that we want to achieve in a free and open internet and all of the other good things that we all fight for all the time, dividing freedom of expression proponents against privacy activists is a very dangerous development, and it seems to be a legacy of this decision so far. Emma, take it away.
Where to start? And I'll try to keep this somewhat brief so that we have time for more discussion and more questions. But I was trying to think through from the perspective of an outsider, someone from the US, not steeped in either the EU cultural context or EU law anywhere near the depth of Judith, trying to think through what is this reaction of this opinion is bad news for free expression and bad news for the internet. Where does that come from? And one of the challenges I realized I have with the CJEU's opinion is the near absence of the role of the searcher or the person who performs the query in the analysis. And just right up front, I'll say like there's a very good reason for this in terms of the role of the court. The DPD has, the Data Protection Directive has an exemption of personal and household use of personal data of others, so that it was not properly before the court to consider what the individual searcher is doing when they are the ones picking another person's name to be their search query. So it makes sense from a procedural perspective that the CJEU didn't talk about this, but it leads to an opinion where the CJEU is discussing what a search engine does, I think, in a kind of artificial way. They talk about the profile or the lists of links that Google creates about a person. But Google is not necessarily, or kind of correctly described as doing this at its own behest, talking about what is the processing and control of the data that Google does for its commercial purposes. Absolutely, it does that. But what a search engine is doing is different from the data aggregation aimed at making a profile that you might expect of, say, a data broker or an insurance provider or somebody creating a credit report, or even advertising profiles that Google makes through its ad profiles or through its advertising services, where you've got an entity that, yes, is doing all of this searching and collecting and assembling information about people, knowing and understanding that what it is doing is about people. Looking at search, generally, you've got, yes, crawling and indexing of information of everything that is available on the public web. Whether the list of results that are generated when another user puts in a search query is a profile of a person, or that person's dog, or the dry cleaning service down the street, or answer to a question like, how do I convert miles into kilometers? This doesn't necessarily matter according to the work the search engine is doing. It's completely, the relevance of these list of results as a profile about someone's personal data is really in the hands of the person deciding to search for that term. So we end up with, I kind of describe it as a search engine is creating the potential for the generation of profiles about people that include their personal data, but it's this third-party other searcher who's calling those profiles into being. And so this is the kind of complex interaction between multiple parties. It's not just Google and the data subject, it's Google and the data subject and the newspaper and Google, which I know is a whole other fight in Europe, and the user who's doing the search, and Google and the data subject and the newspaper or other, actual host of the information about the data subject. It's this complexity and the court's kind of treatment of the privacy interest of the data subject versus the commercial interest of Google, and references to a kind of generalized public interest, or there's one point where the court kind of describes the legitimate interests of internet users potentially interested in having access to the information that a data subject is asking to be removed. But if I'm making a query about, Mr. Costeja Gonzalez, I'm not potentially interested. I am definitely interested. I am expressing a clear and direct interest in finding information about him. So I thought it was interesting you brought up the DMCA as an obvious example of a notice and takedown regime. But that's a notice and takedown regime which, any number of us could put forward critiques of that. But at the very least, what it does is have things incorporated into it that are not just about the interests of the search engine or the content host, whoever's receiving the notice, and the copyright claimant. There are procedural safeguards worked in to safeguard the interest of others. There's the right to reply to a notice, to file a counter notice and say, I challenge this assertion that this information should be taken out of public access. There's what Google does when it takes down information under a DMCA takedown notice is put a advisory at the bottom of the link, so that you have that cueing effect to the person who's doing the searching that something has happened here to, you, the searcher, are trying to create a list of something, and Google is giving you the information that a third party, not Google, has affected.
Actually, that was a
results.
suggestion Jonathan Zittrain made, that Google used to have Mike, could you turn off your microphone, just because it seems when there are three on, we get this booming sound. Google suggested Google used to have a feature that allowed people to comment on links, and apparently it doesn't have it anymore. And he was there saying, what about bringing back something? Are there alternative ways that you could to achieve an effect of redressing the balance without removing the information? Could you use comments? I think it's interesting that you bring up the searcher, because actually I was wondering when Judith was speaking, and by the way, as soon as I finish saying this, I'm hoping there'll be a bunch of you at the microphone to scream comments and imprecations. I wondered did Google ever try to make the argument that they're not processing data on their own behalf, but on the behalf of the searcher?
No, they can't do that. I mean, we had this chat last night already.
I missed it.
As I said before, it's all quite technical, really, but the Data Protection Directive only applies to data controllers. Now, a controller cannot process. A controller is somebody who processes data under the directive, and processing for purely private or household purposes is not covered by the directive. So an individual searcher who is doing a private search is not processing data under the Data Protection Directive, and that is as it should be, because just imagine if you all doing searches and putting stuff on Facebook and telling your mother about stuff and publishing your baby's photograph. If that was all data protection controlled, we'd have a whole set of new problems. But can I just make one point with regard to the public interest as well? You said there is a definite interest of the people searching, and I agree with you. There is people are interested in all sorts of stuff, and the court doesn't deny that. I think what the court basically says is whether or not that interest in finding this information is legitimate.
Caspar Bowden had a great quote about this. He said, "Neither Article 19 nor any other instrument says there is a right to Google and delve deep in the past of quite ordinary people for no particular reason."
Yeah, and I think that is possibly where where the cultural difference comes out, because I would say that is something that you have to have a good reason, which is why I used the example of the politician who was caught with his hands in the till. You have a real proper reason to find out about that. Whether or not you have a reason to find out about whether that self-same politician had an affair with somebody is a completely different question that would probably be decided differently in every single European state, never mind the US.
Article 19 of the UN Universal Declaration of Rights and of the ICCPR specifies a right to seek and to impart information. It's a right that applies to everybody.
That is subject to the limitations of the second
Don't
paragraph.
skip to the end. We got to have all the middle part.
But you're representing it as an absolute
You
right,
haven't
which
given me a
isn't.
chance to fully represent it yet. Of course it's a qualified right, but what it does in the language of Article 19 as it stands by itself before it's joyfully qualified by my German colleague, is a right to seek and impart information, and it doesn't. If that was understood to be a constrained right, it would have been very easy for the drafters of the international human rights instruments to say for legitimate purposes, but they don't. And the reason they don't is that once you enshrine the idea that you're only able to seek information for legitimate purposes, or only able to impart information for legitimate purposes, and the decision of what is legitimate is not left to you as a free citizen in an open society by default, subject, of course, to the appropriate qualifications in the human rights instruments. Once you do that, then essentially you've given away everything that you have in your freedom of inquiry. You've decided that governments can specify what is, narrow fields of inquiry that are legitimate and exclude everything else. The case is that, we made a joke about, I think Judith made a joke about whether you could repost information, gather information, post it on Facebook, and you wouldn't be a controller. But it seems clear from the actual language of the decision that anyone could be a controller of data subject to the EU privacy directive. The actual definition says in the Directive 9546 states, and I'm going to quote it, controller shall mean the natural or legal person, that means it could be an individual human, public authority, agency, or any other body which alone or jointly with others determines the purposes and means of the processing of personal data, where the purposes and means of processing are determined by national or community laws or regulation, the controller or the specific criteria for his nomination may be designated by national or community law. Now let me just say.
And then Article 3 says that the directive shall not apply to processing by a natural person in the course of a purely personal or household activity.
Right.
So you cannot be a
well, let me give you the example. I'm a lawyer who's interested in the decisions of privacy regulators. And so what I do is I gather court decisions vindicating the right to privacy and that name the parties and that name the facts at issue, and I post them without modification to my public website. At that point, it's not my purely personal inquiry. At that point, I'm publishing it because I want to share it with the world that this is what privacy regulation looks like in the wild. And at that point, it seems quite clear that I'm subject, provided I meet the other jurisdictional requirements, that I'm subject to the privacy directive, to the data directive, and that I can be forced to remove this stuff from my blog, from my website. And I think that is a very, very troubling outcome. And I think, Judith, you actually admitted yesterday that this can be made to apply to individuals in certain circumstances.
Okay, I want to give this guy who's been trying to get up and say something, the chance to say something.
Thank you. This one? It's been a great panel and a lot of good insight here. Judith, I think I'd like to direct my questions to you. The first is...
Is that microphone on?
Is it on?
Yeah.
I need to get closer. My memory is I lived and practiced privacy law in the EU for about 4 years, so I know just enough to be dangerous. I think it's called the Advocate General, but the party that makes the recommendation to the ECG, it came up to a very different conclusion, very different rationale. And my memory is that traditionally the ECG has usually followed the Advocate General's recommendation. I wonder if you could just comment on that and if that has any significance. Perhaps you don't think so. My second question is the breadth of the decision. I wonder if you could speak a little bit. I'd like to hear your thoughts on that because the language does seem to be capable of being very broadly construed. And I wonder if there's some principles of case law interpretation in the EU which may be different than the US, because you seem to be saying it's much more constrained, and I'm hearing from my American colleague it has the potential to be much broader. And the final question goes to the remedy. I'm slightly confused about this, because if we were going for efficiency or effectiveness on the right to forgotten, does it not make more sense to hold the newspaper from preventing it from publishing the link? Or in this case, it is a newspaper, but anybody else who's perhaps publishing the link. Do we really want a bunch of hippies in Mountain View making the decision about what should be published, what should be published and what should not be? Are we not handing too much power to private individuals as to what should be made available? And what about, you gave a really good example about the politicians and how those links should not be deleted. But what about where the analysis changes over time? The individual has been convicted, been successful in their right to forget, perhaps because they were convicted by fraud, time has gone by, they've served their time, but now run for public office. Do we not need a right to remember? Who advocates for the public in those situations where those facts should perhaps be remembered? Thank you.
Okay. Can you just quickly repeat the second one? Because I got the first and the third, and I've forgotten the second now.
The possibility of the broadness of the language that really anybody could be a data controller, other organizations, individuals, and I was wondering if there are any principles in the EU for interpretation of case law which suggests that case law is much more narrowly interpreted versus perhaps in America where you could bootstrap a lot more in.
Okay. So the first question with regard to the Advocate General's opinion, that's true. The Advocate General opinion was delivered last year, and the Advocate General basically recommended that Google should not be considered a data controller. Now, that was actually received in Europe with a certain amount of confusion because of what I previously called the dichotomous nature of the status of somebody who processes personal data. And this is where the court really didn't have anywhere to go, okay? So you are either a data controller or you're a data processor. So if you're a data processor, you are processing this data on behalf of solely on behalf of somebody else. You're doing someone else's bidding. That is the definition of a data processor. As soon as you have even a hint of your own commercial purpose when you're doing this, you are basically determining the reasons or the purpose for which that data is processed. And then you are a data controller. Now, the reason why I welcome the way in which the court resolved that is that as a lawyer, the court basically didn't have the ability and the right. This is not the common law. They didn't have the right to create a third category out of thin air, okay? So they had to go for one or the other. And really, if you look at the facts, then they really only had the ability to go for data controllership, because if they had done it any other way, that would have had knock-on effects for the definition of data controller in many, many other areas. And quite frankly, what Google does here, it does have its own commercial purpose. So I suppose, even if you take away everything else, that it may be doing it also on behalf of the searcher, that it may be doing it also to give publicity to the website that publishes initially, it may be doing it all for all of these people as well, but also it does it for itself. And as soon as it does it for itself, it is a data controller. Now, this whole idea, this is actually something that I always try to explain to people, is for me it is a bit of an urban myth. This whole idea that the ECJ always follows the Advocate General, I don't see that, quite frankly. I mean, this is something that almost always comes up. My own colleagues, they always just like, oh, the court, and all the articles that go for court decisions, every time they go elsewhere, just like, the court, which normally follows the Advocate General's decision, has decided in this case. Now, if the court always decided, followed the Advocate General's decisions, we wouldn't need a court. We would just ask the Advocate General to tell us what to do, and that'll be that. So I would not, believe that. That is urban myth, I think, legal urban myth. So really, the Advocate General made an argument that left a very important legal question unresolved, and it didn't give a particularly good reasoning for it. So the court basically looked at the facts, looked at the law, and said, no, this is not the right way to go, this is the right way to go. So that's the first question. The broadness of the language. Well, I personally like the Data Protection Directive, but it is not without fault, okay? And the fact that it has the main fault that I see, and this also plays into the third question, is of course that it is a legislative instrument that includes substantive provisions, okay? It does not include procedural provisions. And that basically means that putting that together with the very complex way in which judicial review and interpretation works at European level, in that you have to go to the member states' courts first, and they have to decide whether or not something is kicked upstairs, it takes a long time, which is why, 1995 is a long time ago, and we are having the court define what a data controller is in 2014. Not an ideal, efficient system, and I say this as a German. So the thing, the broadness of the language, we have seen that, in fact, in 2003 in another decision called Lindquist. I'm not sure how many of you are familiar with that, where so basically this is where some of our problems come from with regard to whether individuals can be seen as data controllers, because in Lindquist basically the court said, well, if you put it out there in a blog or something like that, yeah, you may be. Now the problem is that that decision was taken and everybody subsequently ignored it. Okay, so really taking Lindquist to its normal conclusion, everybody who's posting on Facebook would be a data controller. And everybody, for that reason, has ignored Lindquist since 2003. So one of the things that we're currently trying to do in the data protection regulation is to be better at regulating this area. So I'm not saying that there isn't a broadness of language. What I'm saying is we are kind of aware of that, and we're trying to address this in the new regulation. So from that point of view, finally, implementation, I agree with you. Okay, the one thing that the court did not do, and again, I would say to you that you have to look at what the court can do in this context. And the court can only interpret or answer the questions it was asked. That's its competence. And it was asked to interpret specific legal concepts in the directive. It has decided to basically pronounce on principles. And what it basically has done, it has thrown the ball back to the legislator and the industry. And we now have two choices. I completely agree with you. It shouldn't be Google to make these decisions. I hate that idea. Everybody I know in Europe hates that idea, be they digital rights activists or be they privacy campaigners. And we now have a job in front of us to figure out how to do that. The way I can see this, we can either go the legislative route, we can either have the EU legislator sit down and come up with another statute that regulates the procedure for this. I find this unlikely to happen. Or we can go down the self-regulatory route. We can say to the industry, come up with some guidance that, together maybe with the data protection regulators, come up with some guidance, some decision trees, and a procedure that potentially allows, and I would support that allows the other side a voice, that allows the website the person on whose website the information was originally published to put his or her side of the story. And let that decision be made by experts rather than an algorithm or just Google take everything down because that's easier.
Okay, so we've got 5 minutes left, and I didn't see anybody else jumping up to, oh, God.
Let Rob ask his question.
While you're speaking, I'm gonna give Mike and Emma a last chance to sum up. And the question I'm gonna ask you is there any way this could be implemented without, and mediate the harms that you see coming? And you can, what is your question?
Okay, so this is a hypothetical I raised when I wrote about this. Suppose someone does something, they commit some minor crime in college and they have it expunged from their record. The EU ruling says the counter to your right to be forgotten is the public's right to know. This person then runs for office, say, on some tough on crime platform. Does Google then, on their own, get to put that link back in the search results? How does anyone else know to have a petition, have it put back in since it's gone down the memory hole?
You can add add that to my question. Actually, there's an example of that right now, which is that if your conviction has been expunged from your record in the UK, for example, but you're applying for a visa to the United States, you have to get a certificate from the Association Chief Police Officers to submit to the U.S. consulate. Anyway, go.
Well, so I mean, to answer your question, I really don't think search is where this kind of thing can get implemented. And just looking solely at kind of the volume of data processing that's going to happen. If, according to reports in the news, Google got 12,000 requests on the first day that they put out their form for people in the EU to file a request to have links associated with their name taken down. So if you spend 5 minutes per request analyzing that, and think of the first time you heard of the Google Spain case, maybe it was this morning, maybe it was before, think of the first time it took you to sort of wrap your head around what was Mr. Costeja Gonzalez's problem, what was the context, and what did you think was the right way to decide that? I think 5 minutes is a low estimate, but let's go with 5 minutes. That means on the first day they had 1,000 hours worth of human review to do, which if you immediately start with a really well-trained staff of 20 people and have them work 10 hours a day, that's what, 5 days. And then at the end of that 5 days, you're done with your first day, but you also have days 2 through 5 now in the backlog. I just don't see you hire an army of people, you come up with some really high barrier to even making a request in the first place so that you have many, many, many fewer requests, or you end up automating some part of this procedure, and that's where I start getting really nervous about who are we asking to do this automating and what are the possible pile-on effects. So I think if it's concerns about information that was public at some time and under, in some countries is considered reasonable to be made unpublic, you've got to go to the source. I don't think the intermediaries like search or other kinds of information location tools that may exist now or in the future, I don't think they're going to have anything like the right balance of incentives to do this right.
I want to come back to the Wikipedia example because Wikipedia is close to my heart. one of the things that, if you know anything about how Wikipedia articles are produced, you know that there's an injunction not to do original research. In effect, you're told not to do reporting, not to, you're supposed to draw from other sources and base everything on public sources. And effectively, you are assembling sources and links to other public sources. It seems clear that that the distinction between doing this stuff for yourself and doing it for someone else is not nearly so cut and dried. Every newspaper that I ever worked for was a for-profit operation, even if the profits have declined over time. So I think that the notion that the line between commerce and serving others is easily drawn may be there in the distinction between processing and controlling in the data directive, but I think in practical terms that's pretty mushed together. And even Wikipedia, which of course survives on donations, which are a form of payment for what it does, has value not because the people are doing this research for themselves, but they're doing it for others, but they also have reputational benefits for writing these articles themselves, and it helps people get jobs and that sort of thing. I think that if we believe that society has fundamentally changed because of the internet and the ability to seek data and the kind of connectivity that we have and the ability to dig into our own pasts and into other people's pasts and into history far more than we ever have before. The question is, how do we turn back the clock? Do we think privacy is an interest that does that? I think privacy is not the right way to talk about it, because I think properly we should understand privacy rights as commanding the non-publication of private data. But once the data has been published lawfully, it ought to be considered in the public domain and searchable, and it ought not to be erased and deemed irrelevant because so many years have passed.
Okay, we are going to have to stop. I think that's the next panel assembling in the back there. Thank you all for coming, and thank the panelists, if you would.